Welcome to this event that's looking at the development and growth of problem-solving courts in New Zealand. New Zealand has numerous problem-solving courts which deal with matters such as addiction, homelessness, family violence, mental health, and youth offending. And each of these courts embrace therapeutic jurisprudence principles and seek to address underlying causes of offending. And now with the Ministry of Justice in England and Wales currently seeking to expand the number of problem-solving courts or the intensive supervision court pilots following the independent sentencing review, this event forms part of our work to support these initiatives by sharing insights and best practice from a similar jurisdiction to our own and learning from the expansion that New Zealand has gone through with its various problem-solving courts. So for this seminar, we're very privileged to have two excellent speakers who will speak for kind of roughly 15-20 minutes each, leaving ample time for Q&A at the end. So firstly, we will hear from Oliver Fredrickson, who is a New Zealand criminal lawyer and who we have the pleasure of having with us, who's currently completing a fellowship at the centre. Oliver previously worked as a judicial assistant for the Chief District Court judge, during which he visited problem-solving courts across New Zealand and played an important role in the design and development of the Te Ao Mārama court, which we'll hear about later as well. And next, after Oliver, we will hear from Judge Malosi, who is the acting Chief Judge of the District Court of New Zealand and the Principal Youth Court Judge. And in 2010, Judge Malosi established the Pasifika Courts in Auckland, which are monitoring courts for young offenders of Pacific Island heritage. Her Honour has also been instrumental in launching the Family Court, Family Violence Court, and Alcohol and other drug treatment courts in Samoa. And more recently, Judge Malosi has overseen the implementation of the Te Ao Mārama, which is a new vision for the District Court of New Zealand, which seeks to integrate best practices from problem-solving courts into the mainstream courts as well. So we're really excited to be able to hear from her in terms of what New Zealand has been done about taking problem-solving courts initiatives and the kind of ways that they work and integrating that into mainstream proceedings as well. And then after all of that, I'll open up to the Q&A. So again, please submit your questions throughout the event on the Q&A function, which you can find in a tab at the top, and we'll go through those at the end. So we hope you enjoy, and I will now pass over to Oliver.
Wonderful. Thank you very much, Vicki, and good morning, everybody. And good evening to Judge Malosi, who's in New Zealand on the other side of the world, 12 hours later. I'm just going to, first of all, very quickly set the scene for today's conversation. And I'll do that by first outlining some historical context, which orientates the discussion in Aotearoa, New Zealand. I'll then provide an overview of the problem-solving courts that we do have in New Zealand, how they work, how they were established, and how they're performing. And then I'll very briefly just touch on the Te Ao Mārama model, the new model for the District Court of New Zealand, which, as Vicki says, seeks to identify and implement the best practice features that we have in our problem-solving courts in New Zealand into the mainstream District Court. Just very briefly on that term District Court, just so we all know what we're talking about. In New Zealand, our District Court is a combination in UK terminology of the Magistrates Court, the County Court, and a bit of the Crown Court as well. So it has 4 divisions of jurisdiction. It has the criminal jurisdiction, the family court, youth court, and deals with some civil matters as well. So it's a large institution with a wide jurisdiction. And in the criminal space, it deals with 95% more or less of all criminal matters. So when we're talking about justice reform and criminal justice reform, the District Court of New Zealand is quite naturally the first port of call. So with all of that in mind, I thought the way to start today's discussion is with a bit of history and a bit of context. And I think that's important because in order to understand what's currently happening in New Zealand and what's happening in the future, you have to understand what's happened in the past and how we got here. And so very, very briefly, I will sketch through some history of New Zealand that has led us to where we are today. And I'm going to start right at the very start, around 950 to 1250 AD. when the first people arrived in Aotearoa, New Zealand. And they did from the Southwest Pacific. They arrived in New Zealand. They established communities and culture in New Zealand, which we now know as the Māori population of New Zealand, the indigenous population. And they remain in New Zealand pretty much undisturbed and uninterrupted for several hundred years, developing their culture and their identity. And then in October 1769, James Cook and his crew on the Endeavour arrived on the shores of New Zealand. And shortly thereafter, for the years and decades that followed, were joined by a number of British settlers and missionaries that joined them in New Zealand. And that development caused somewhat of a friction between the indigenous Māori population and the British settlers. And that culminated in February 1840 with the signing of the Treaty of Waitangi, or Te Tiriti o Waitangi. And that's the founding document of modern-day New Zealand. There are fundamental and irreconcilable differences in the two versions of the document, one in English and one in Te Reo Māori. I won't get into the minutiae of that, but suffice to say for these present purposes, in the Māori version, the Māori chiefs agreed to give up governance over the British subjects that were in New Zealand at the time, whereas in the English version, it appeared as though the Māori chiefs had given up sovereignty over the entirety of New Zealand altogether. The overwhelming majority of the chiefs signed the Māori version, but nevertheless, the British Crown seized upon the English version to assert sovereignty over the entirety of New Zealand. And following that, in the decades that followed, there was widespread loss of Māori land, Māori language, culture, customs and traditions. When the treaty was signed in 1840, almost all land was in the hands of Māori, was owned by Māori. Just 50 years later, that was less than a third. And so as that trajectory continued past the turn of the century and into the post-war period, Māori, after the Second World War, like many New Zealanders, migrated from rural areas into the major urban cities. When they did so, they were disproportionately present in the criminal justice system. So they were disproportionately arrested, convicted and imprisoned. And young Māori boys and girls were disproportionately uplifted from their families and placed into state care. And just one statistic that I think encapsulates all of that and always staggers and sobers me is that for Māori men born in the 1970s, 40% had served a sentence of imprisonment by the time they were 35, 40%. So that historical context is what laid the foundation for, and Miranda, I'll ask you to change the slide now, please, a series of calls for transformative change to the New Zealand justice system. In the late 1980s, there were a series of what are now considered to be seminal reports which criticised the way the justice system was operating, and specifically the criminal justice system. It was said in these reports that the system prioritised punishing individuals as opposed to trying to rehabilitate. The criminal justice system failed to identify, much less address, any underlying causes of offending. Even if they were identified, the support services were so poorly coordinated that they did little to actually address them. The justice system did not support Māori. It was entirely monolingual and monocultural, and it had adopted all of the features of the British colonial system and none of the existing Māori justice system. And it also failed to support victims and their families as well. So these reports painted a pretty grim picture of the justice system in New Zealand in the late 1980s. And the overall thesis was that people were leaving the justice system and leaving our courts feeling as though they hadn't been heard, they hadn't been seen, and they hadn't been understood. And so the call for transformative change was voiced and something had to be done. Miranda, I'll ask you to change the slide, please. One of those initiatives, or one of the responses to those calls for change, was the emergence of problem-solving courts. As you'll see on the screen, I hope, from around 2007 onwards, there was a quite significant proliferation of problem-solving courts across New Zealand. And these were almost always organically developed, usually judicially led initiatives, a judge in a particular community or a particular area identifying a need, identifying something going wrong and trying to do something to make it better. Because they were organically developed, these problem-solving courts operated in their own unique ways, tailored to the particular community in which they served. And so they embrace the idea of local solutions for local problems. And Miranda, I'll ask you to change the slide, please. These problem-solving courts in New Zealand can be broadly categorized in the way outlined on the screen. So there's, roughly speaking, 6 categories of problem-solving courts in New Zealand. I will speak about categories 4, 5, and 6. Category 1, I'll leave for today, although it's an interesting development. Not strictly speaking a problem-solving court. In New Zealand, we have a range of diversionary panels in which an individual is diverted away from the court system altogether, and effort is made to identify and address underlying causes of offending, address them, and deal with that without recourse to going through the court system. So very interesting development, very positive initial signs, but not strictly relevant to today's discussion. In terms of the second category, youth court, Judge Malosi is the principal youth court judge of New Zealand. She established one of those 4 courts on the screen and plays a significant role in that space. So I'll leave that for her to discuss as well. So moving to the third of those categories, and the one that is probably most relevant to today's discussion, are the intensive supervision courts in New Zealand. We don't really use that term, intensive supervision courts, or not so far as I have seen, but I've read the UK Ministry of Justice's publications and their definition and description of intensive supervision courts, and I think at least these 4 courts in New Zealand would meet that definition. So the 4 of them on the screen, so that's the New Beginnings Court, Court of Special Circumstances, Matariki Court, and the Personal Intervention Needs Court, all were established and operate completely independent from one another. The top 2 in major cities in New Zealand, the bottom 2 in smaller regional areas, and operate necessarily in specific and unique ways to cater for their communities. But nevertheless, they all embrace principles of therapeutic jurisprudence. They all have common features of best practice, and they all follow a similar process to identify and address underlying causes of offending. And so the way that process works, generally speaking, for these 4 courts, is that an individual will have been will have been convicted or pled guilty to a criminal offence in the mainstream district court, and then it will have been identified that there is an underlying cause of that offending that, if addressed, could break a cycle of reoffending that has emerged. And from that identification, the individual will be referred into the problem-solving court with their consent, of course, and that referral can be undertaken by the presiding judge or defence counsel or prosecution counsel, or in some courts even a family member or a support person of the defendant themselves. Once the individual is referred into the problem-solving court, they will ordinarily meet with a court coordinator, so a role that sits within the middle of these problem-solving courts, and that's somewhat as a pivot point for all things coming in and out of the court. They'll meet with the court coordinator and they'll discuss the particular circumstances of this individual's situation, and they'll determine whether or not they meet the eligibility criteria which applies to the particular court. If they do meet the criteria, they will then come into the problem-solving court and have a first hearing before the presiding judge. And that's important because in these courts, the judge takes an active and involved role in the monitoring of this individual's progress. And it'll be the judge who has ultimate, not discretion because there's a criteria, but the ultimate say on whether or not they're admitted into the problem-solving court. If they are, then the individual will become a part of this court, and the first step in that process is that they will meet with a representative from a community organisation that is linked with the court and is in charge of the provision of support services to try and address those underlying causes of offending. So they'll meet with a representative from this community organisation. A personalised plan will be devised, will be prepared, which looks to address or looks to identify, first of all, those drivers. So it could be mental health, could be substance use, any of those underlying causes of offending, and then a plan will be devised to try and address them with programs or treatments or other initiatives at play. So once that plan has been prepared, they'll go to have frequent monitoring hearings before the presiding judge, who will monitor the progress of that individual through the progression of their plan. And at each of those hearings, the judge will take a keen interest. They will speak to the individual in plain language. They will ask them about their progress, about their circumstances, about what's working, about what's not working, about what they need. And they'll monitor their progress towards completion of that personalised plan. Once the plan has been completed, then the individual will graduate from the court. They will have a ceremony celebrating the progress that they've made, and then the individual will ultimately be sentenced from within that court by the presiding judge, who has overseen their progress from start to finish. And so as a result of that progress and that development, they will receive a significant mitigatory credit for that progress that's been completed. And so these four courts in New Zealand, which can be described as ISCs, work generally in this way, and they've had significant successes. I'll just rattle off a few statistics arising from the evaluation of the Special Circumstance Court and the New Beginnings Court. In the Special Circumstances Court, there was in the evaluation, the cohort that was under evaluation had a 75% reduction in offending. In that cohort, 45% of the cohort did not reoffend at all in the relevant period, and almost all reported that they had a positive experience within the court and enjoyed being treated, quote unquote, as a real person. Similarly, in the New Beginnings Court, in the evaluation cohort, there were fewer arrests, fewer nights spent in prison, healthier lifestyles, and better housing situations for those who had passed through the court. So that is, in a nutshell, the ISCs that we have in New Zealand, how they operate and how they've performed. More than happy to answer any questions towards the end of this session, as the case may be. But before that, I'll just quickly run through the last three categories of problem-solving courts that we have in New Zealand a bit quicker. So we have three drug courts in New Zealand. They're all called the Alcohol and Other Drug Treatment Court. They all follow the same model, which is a high risk, high needs model. So high risk of reoffending and high needs to avoid that occurring. They all follow a three-phase approach. So in the first phase of the Alcohol and Other Drug Treatment Court, the individual will receive treatment for their alcohol or substance use. That will either be in the community or in a residential facility. In the second phase, they'll continue that treatment, but they'll also receive any support that might be necessary for any other underlying causes of offending. So potentially counselling or anger management classes or assistance with obtaining a driver's license, anything else that might have been driving the offending. And then in the third phase, they'll look to the future and they'll prepare an ongoing maintenance plan, which will try and ensure that once they do leave the court, things will be stable and they'll be able to maintain the progress that they've made. So this could include employment or stable housing or anything like that. And similar to the ISCs, once the individual has passed through those phases, they will graduate and they will again be sentenced within the alcohol and other drug treatment court. First of all, we have one mental health court in New Zealand. It's probably better termed a mental health list. So it sits in Auckland, and on a particular day on a particular month, so say it's every second Thursday morning of every month, they will list all cases in that list, ones with a mental health component, so an individual who might have challenged their ability to stand trial or be advancing a plea of insanity will be listed on that date. And so it allows the presiding judge, the court, and everyone within it to know that, okay, well, when the mental health list is sitting, every defendant will have some consideration of mental health at play. And so all of the accommodations and the best practices that are appropriate can be employed, and everyone that needs to be in the courtroom is in the courtroom. So a forensic nurse, a clinician, etc. So that by creating a designated list where all cases are listed on the same day, it allows the judge and the court to employ those best practices with a bit more precision. And then finally, we have 8 family violence courts in New Zealand, which operate in a similar way to the mental health courts. They're a designated list at which all cases within the list will have a family violence component, and it ensures that all the support service providers are present and available, and they can identify and address any underlying causes of the offending. So those, in a nutshell, a very quick and fast-paced nutshell, and I apologise for the dump of information, but that in a nutshell is the status quo in New Zealand and the state of problem-solving courts that we have. As I say, more than happy to answer any specific questions that might arise, but that is the current situation with problem-solving courts in New Zealand. And as I mentioned with the ISCs, they have performed very well, and they've generated very positive outcomes for the individuals that have had the opportunity to go through them. But necessarily and naturally, they can only extend and reach to a finite number of individuals. And although that's positive for the individuals that have that benefit, the overwhelming majority of people will not have access to these problem-solving courts. And so the next step in New Zealand's journey, which Judge Malosi will talk about in greater detail, is identifying what is it about these problem-solving courts that works so well. What are their best practices that are really resonating with people who go through them, and how can we employ those best practices into the mainstream court, and so they're available to everyone, and everyone can have that benefit of the best practice features. So Miranda, I'll ask you to just change to the next slide, but I've probably jumped the gun a little bit. And so that therein lies the vision of Te Ao Mārama, which is the new vision for the district court, which looks to integrate those best practice features so that everyone can come to the court and they know that they'll be seen, they'll be heard, they'll be understood, and they can meaningfully participate in the proceedings that relate to them. So that is the current state of things in New Zealand. That's where we are, that's where we've been, that's where we are, that's where we're going. I'm grateful for your attention. Again, it feels like a bit of a lecture, but thank you very much for your attention, and any questions that might arise, I'll be more than happy to answer.
That's super helpful and informative. Thank you, Oliver. And there's a number of people I know that are on this session that are practitioners, kind of judges or magistrates or practitioners within our existing problem-solving courts. So there's lots that will feel really familiar as well, but it's also super interesting to hear about how the journey has been for New Zealand in terms of really expanding some of the work that you're doing. Do please be putting questions in the Q&A. They won't have come up just yet because Miranda has to do something behind the scenes with publishing them, which I don't quite understand all the tech side of, but do keep putting questions in the Q&A for us to have at the end. But I'm now going to turn to our next speaker, Judge Malosi, and we're really, really grateful to have you with us, especially because this is your evening time. So you are definitely eating into your post-work working hours. So we massively appreciate you giving up the time. And before you do your presentation, Judge, I'd be really keen to just speak to you a little bit about some of your experiences in terms of being able to grow and spread problem-solving courts in New Zealand. So in terms of, obviously you established the Pasifika Court in Auckland. Could you give us a little bit of an overview about what the Pasifika Courts are and how they work, please?
Sure, thank you, and good morning to friends and colleagues on the other side of the world. It's a joy, Oliver, to see you blossoming in the way that we predicted you would, and it's time to come home, Ollie. But I'll eagerly await your return. So the Pasifika Courts, as you say, Vicki, are based in Auckland. Here's a fun fact. Auckland is the biggest Polynesian city in the world. So it makes sense that we would have Pasifika Courts there. But as someone of proud Samoan heritage, it's a sadness that we have to have them at all. But it is what it is. Our Pasifika Courts, only two in the country, and I'm not looking to expand them, are held in church halls, which is not surprising if you know anything about Pacific people and Polynesia. Christianity is king. So we were naturally drawn to church halls as a venue. You will appreciate that wasn't an easy decision. Do we go to a Presbyterian church, a Methodist church, a Catholic church, a Tongan church, or a Samoan church? So those dilemmas had to be navigated. All of our court hearings in a Pasifika court start and end with prayer. That's a tricky thing to navigate in our so-called secular society, but it's so ingrained in Pacific culture. People maybe have missed the fact that there is a difference between religion and culture, and just see that that's something that needs to be done in Pasifika spaces, but that's something we've been able to navigate. What's really key in terms of difference is the involvement of elders in the court process. Elders sit alongside the judge and keep the process safe through holding those cultural practices at the beginning and end of each case. They will always end with words of encouragement for the young people and their families, and are key in engaging young people and their families in the process in a way that I don't see in the mainstream court. The elders are always able to connect to some part of the young person's genealogy and lineage, because the Pacific is so small, the islands are so small, and the numbers of people who migrate to New Zealand are so big. So they are always able to find at least one family member who has done good deeds in their life, and very often great deeds in their life, that you can physically see the young person sit up straighter when they know that that is someone from their family, from their background. So there are the end bits of the Pasifika Court which the elders hold, but the middle bit is clearly the court process, where the decisions are made solely by the judicial officer, but always respectful of the cultural norms and of the views that the elders might express, but always really clear about the judicial independence and the statutory obligations we have to apply the laws to the facts of the case. And sometimes that involves us making hard decisions like, sorry, you've not done good enough, you're going back to the mainstream court, or sorry, you're going off with the police today and not going home. So it's still a court of law and the same laws apply.
Excellent. That's really interesting and helpful. Thank you. And I'm definitely taken away there. Although the Pasifika isn't obviously specific to us within England and Wales, but what's coming through is the kind of the importance of culture and community in some of the problem solving court initiatives. Thank you, Judge. And just sort of turning to establishing a problem solving court, could you talk about the context? What kind of caused you to feel that a problem solving court was necessary in your community?
We followed Māori into the space, and it was really, really helpful to have Oliver outline that history in Aotearoa in New Zealand. So we are Polynesian peoples together with Māori people. We travelled, different views about where we travelled from and where we stopped and who got off where. But it was always the plan that we would hold courts in Indigenous spaces for Māori youth. That's the rangatahi court you saw in Oliver's presentation. And it was always planned that the rangatahi courts would be set up first. Then we would listen for the voice of the Pacific community and see whether there was an appetite. And once my people, I'm Samoan, once my people saw the Māori people have their own court, we want some of that. Excellent. Because they could see how culture and language had a place in the justice system and wanted to carve out their own space. So we took the learnings from the rangatahi court and applied them to the Pasifika court. And importantly, we struck while the iron was hot, because the ministries, the government agencies had been taken into the space by Māori, so it wasn't starting right from the beginning. It was slipping. It was almost like in the still of the night coming in and saying, we'll have some of that too. And people were not so overwhelmed by the thought of that. So timing was everything for us.
And were there teething issues that you perhaps didn't expect?
Actually, I thought about that and wondered whether I'm rewriting history in my mind, because I can't think of really big challenges that came our way that we weren't able to overcome. And I'd like to think, Vicki, that it was a matter of having been in this game so long that we knew what was coming. We knew what we were up against. We knew what we had to anticipate. And we had the conversations that needed to be had. And that's a really, really huge part of setting up problem-solving courts, is doing your homework and building authentic, genuine relationships with community who ultimately have to own these solutions. And we have to respect the knowledge that we have and that they have, and how, if we bring that together, we have the best chance of finding meaningful solutions. We don't have all the answers. That's why we're looking for problem-solving courts. And we have so many problem-solving courts in New Zealand because we have so many problems.
And it really kind of speaks to that collaboration. That's what's coming through quite loudly, that kind of collaboration, those relationships between all the different agencies, and including the people, the clients that are coming before the courts as well.
Yes.
Excellent. Judge, I've got loads more questions for you, but I'm slightly worried about time, and I'm really keen to hear from you about the Te Ao Mārama program as well that you're kind of leading. And I understand you've got a presentation for us to talk about the kind of
it's a really quick one. Happy to go to that. Yeah.
Yes, and then we can pick up some more questions as well at the end from others as well.
Sure.
Miranda, I think, do you have slides to share for Judge? Excellent. Thank you, Miranda.
Thank you. If you go to the next slide, please, Miranda. Te Ao Mārama literally translates into English as the world of light. So in Ollie's presentation, he talked about over 40 years of reports which were telling us how bad we were doing. And so Te Ao Mārama is about coming out of that dark period and actually listening to those voices of all of those people that contributed to those reports who told us that we weren't doing good enough. So the important point about this slide is that Te Ao Mārama is a judicial initiative. And I want to loop back to that shortly. If we go to the next slide, and I've jumped ahead. The Chief District Court Judge, Hemi Tomonu, had a vision literally in the middle of the night and dreamt about this transition from night to the enlightened world. And he gave a seminal speech, one of the biggest speeches on our law calendar. And I do want to acknowledge you, Oliver, because you poured your heart and soul into that speech, and it literally birthed Te Ao Mārama in this country, and you will always be able to claim that significant part that you played in that. Judges took the lead and others followed. That's what's really important about problem-solving courts as judges, and I acknowledge my brothers and sisters on this call. We can have all the big ideas in the world, but if no one's following us, it's just a big idea in the world. Te Ao Mārama is for all people. It's a harsh reality of our world here in Aotearoa, New Zealand, that most of the people who come before our youth court, family court and criminal courts are Māori. So there's obviously a focus in that space. Problem-solving courts are often in tension with timeliness, but the choice we have to make is whether we go slower to go further or go faster to simply have it roll around again at some point in the very near future. So the Te Ao Mārama framework was introduced in 2023. We had no money. We didn't need money because we had the best resource of all, which was people. So we launched the Te Ao Mārama framework. If we go to the next slide, please. And these were the problem-solving courts within each of these jurisdictions, which were encouraged to be set up throughout the country. And I won't go through those in any great detail, just move to the next slide. But these are the 8 best practices. The po are the things that hold the house, the structure up. So these are the things that we really lean into. Enhancing connections with local communities. Obviously, we need good information to make good decisions. We need good processes so that children and vulnerable persons are really engaged in the process. We need to listen. It sounds so basic, but it's so important. Alternative courtroom layouts. I'll show you one of those in a minute. Plain language. That's quite an interesting concept. What's plain to you and I is not at all plain to he and them. That's tricky. Toning down formalities. Judges have different views about that. But there's no doubt the feedback is telling us we're too formal and we don't speak proper English. We speak another language, and we do. And adopt solution-focused judging, which you're obviously on a journey in relation to. So all of those 8 best practices will be practices I know that you have in England and Wales. So the next slide, please, just shows. So Miranda, Thank you. So it just shows where they are. They're all in the North Island. They're all concentrated in areas with high Māori populations. And there was, so we rolled out Te Ao Mārama. There was no government funding. We weren't looking for funding, and then we suddenly got $40 million or however much it was. So that came. There's been a change of government. That's gone, but the people still remain, and Te Ao Mārama still remains. So Te Ao Mārama has funding in these 8 locations, but it is for the whole of the district court. And those 8 best practices I showed you are being rolled out in courts where there is no funding. So I think we might be on to the last slide, or almost the last slide. This is an alternative layout. It's not earth-shattering. It's a horseshoe where people get to sit around and face each other. And often the judge will come down off the bench and sit at that lower bench where the registrar sits. And if we just quickly move on to what I think is now the last slide, these are just some comments that came back from the Family Court Care and Protection Court, Solution Focus Court, where people talked about their mana, their worthiness being uplifted. Whānau, that's the WHANAU, that's family felt included, less daunting, opportunity to speak directly to the judge. Now there's a radical thought, someone in court being able to talk to the judge. But so often that doesn't happen, and people don't feel as though it can happen, but it is possible. So that's the slideshow. Vicki, I wondered if the participants might like to hear about how they might go, or how we went about setting up these problem-solving courts.
I think that would be really helpful, Judge. Yes, please.
So just quickly, our experience is that for a problem-solving court to be successful and sustainable, it must be community-led in the first instance. And then community and the sector have to drive it. So community-led at the beginning, and the judiciary and the ministry then enable that community vision and self-help, if you like. Sowing seeds is really, really important, but what I found is that sometimes you need to put the seed in the hand of the right person and point them in the right direction and be an enabler of that journey rather than the conductor of the orchestra. And that's really hard for a judge to do, to sit back and let things evolve. But it's really, really important. Also, as judges, we found that we had to be willing to be vulnerable, because in these spaces where we're having different kinds of conversations and asking of people to let us in, there has to be something that we're prepared to give in return, and that's a tricky space to navigate because we're judicial officers. But it is possible to navigate that space and be enriched personally. I mean, these courts have made me a better judge and a better human being, so there's a lot in it for us. Mm-hmm. Yeah. It's not all we're coming along to save people and turn their lives around. We all find that our lives have been changed in good ways. Judicial leadership is really crucial in working collaboratively, particularly with court staff. They're our hands and feet. They're our eyes and ears too, and they tell us things that we don't get to know in the formal courtroom settings. This is a really, really important tip. Try and develop models that don't require legislative change. All of those courts that Oliver outlined, the Pasifika Court that I've talked to you about, were stood up by judges with the support of the ministry without legislative change. Most of them also were operated out of baseline funding, and that's also a really handy thing if you're able to achieve it, and we have been able to achieve that. Te Ao Mārama was stood up within baseline funding, and not knowing that we would get millions of dollars a couple of years later. If you have to go it alone as a judicial officer, all power to you, but find some buddies and go together. It'll make it easier and more fun. And I guess the final message I want to give is it's easy to keep doing what we've always done. But if you put your hand on your heart and you know it's producing the same poor results, and you get an opportunity, if you're lucky enough to get an opportunity that might produce different results, then I guess I'm asking you, why wouldn't you give it a try? What have you got to lose? If this is what I ask myself, what have I got to lose? Because our current system isn't delivering all that it could for people. So if we try and it doesn't work, well, it's that old saying, at least we tried and we know for sure. And it just means we come at it from another way. So part of the magic of problem-solving courts is that we're always trying to solve the problem, and eventually we will find a solution that can be scaled and can be sustained. And if we try along the way and things don't produce the kind of stunning results that everyone thinks is going to drop out of the sky, then that's not the end of the world. Surely we just keep going, keep trying, and all power to you, and come visit. Seeing is believing, and Oliver will be able to put together a wonderful tour for you, and you'll be well looked after.
Yes, absolutely.
I mean, I think there's many of us that would like to take you up on that offer, I'm sure. So, yes.
And we just had a big delegation visit from San Francisco. I think there was about 40 of them, and it was an incredible two-way experience. Yeah. We learned so much from them, and they tell us they learned so much from us. So I know in this post-COVID world, people are traveling like they used to, but there's no substitute for face-to-face, as lovely as it's been to be remote with you tonight.
Well, hopefully we can take you up on this offer. I'm mindful we've got about 9 minutes left and loads of questions coming through in the Q&A. I'm worried we won't get through them all, but what I would offer, if it's okay with Oliver and with Judge Malosi as well, is if we can maybe gather some responses to questions that we can't answer, and so that we can send those out to people after the event at least, because I'd like to try to get answers. It's been so inspiring, so thank you so much, and we're on a real momentum, I think, certainly in England and Wales. Right. And our colleagues in Scotland and Ireland and Northern Ireland were already well ahead of us in terms of problem-solving courts in their criminal courts over there. Oliver, there's a question that's come through around evaluations and other data regarding your kind of ISC courts. I know you're doing some work around some of that anyway, but that's something that we can share with attendees.
It is, certainly, yes. I'd be more than, I can share my email address, and if there's a way of doing that, Miranda, and I'd be more than happy to pass on any resources that could be helpful, evaluations, process maps, things like that. And I'm doing a piece of work during my time at the centre, pulling all of this information together and summarising the current state of things in New Zealand. I'm not sure if that will be publicly published, but if so, that'll be available. But if not, I'll be happy to send you the primary resources. So I'll put my email address somewhere and you can find me.
Thanks.
Yes, and I may live to regret this, but I'm happy for my email to be shared. I obviously know a lot of people across the whole sector, and will be able to connect different people from different workspaces with their counterparts in New Zealand if they'd like to have that.
That's incredibly generous of you both. Thank you so much. Yeah, I know that will be hugely appreciated. There's another question here, which is, I really liked the multi-agency approach and the involvement of local communities. And you mentioned at the beginning the structural and racial inequalities, which informed the foundations of the problem-solving courts. And the question is, to what extent do you feel that those issues are addressed via the court processes? And you specifically referred to housing, and the question asker is wondering if you could say a bit more about that, please.
Well, that's
You're on the ground. I'll leave that to you. Right.
Well, I think the short answer, without copping out on the question, is it's a work in progress. It took, you know, generations to get to this point, and it'll take hopefully not as many generations to undo it. But what we're seeing in New Zealand, and remember, we're a small population, 5 million in total, we're just one big village, is that we're seeing more and more Māori and Pasifika professionals come in to the space. We've got close to a third of district court judges are now of Māori or Pasifika heritage, and that's only happened since Chief Judge Hemito Moni was appointed. So we're seeing a big shift that's being driven by professionals coming into this. Well, that's being enhanced by professionals coming into the space, and those most affected at the bottom end of all of our markers of society, looking at the system and thinking, maybe I can trust in it. Maybe there are solutions with me within the system. Maybe I will give this a real go this time around and get off this cycle of offending.
That's really helpful. Thank you. There's a question around, I suppose it links a little bit to some of the evaluation in terms of, like, have you calculated the cost and invested and time investment needed as well, and costs? Is there been any cost analysis of the courts within New Zealand, the various problem-solving courts? And also within that question, what do you think are the key differences? Was it the judge time and engagement, or the court coordinator, or is it a combination of those?
I can speak just very briefly on the first part of that question. In 2022, an evaluation of the Alcohol and Other Drug Treatment Court estimated that there was about a 2-to-1 return on each dollar invested. That's a kind of holistic figure, taking into account the reduced reoffending and the social benefit that emanates from that. So that's just one kind of touchstone figure. There may be others. Again, please do get into contact and I can give you some more full information, but that's just one figure.
There's a Te Ao Mārama figure that I can't share because there's an evaluation coming out recently, but it's a stunning result. And in New Zealand recently, we have set up a social investment agency, so a government department that is solely focused on how much bang for the buck are we getting from different investments. So there's a really big focus on looking at the return and putting the resource where we're getting the biggest returns, and the biggest returns are in the problem-solving approaches, is what the overall data in New Zealand is telling us. So from a financial point of view, it seems to be the right approach, but more importantly, from a people point of view, it is absolutely the right approach.
Thank you. I think we've maybe got time for one more question. I know there are many more that are there, but as I said, we will gather responses and send those round to everybody, to all attendees, as well as the kind of contact details and resources that Oliver's mentioned. But there's a question here around if you could say a little more about the sentencing decisions from the courts and how they interact with the support and the treatment. So is the range... How does that interact, I guess, the support and the treatment with the sentencing decision?
Well, there's no doubt that the ultimate sentencing outcome, where there's been an intervention, is less, and significantly less, than there would be had there not been an intervention plan. But that's not but. We are always really, really conscious of being lawful at all times. That sounds like a ridiculously obvious thing for a judge to say, but when you are stretching the interpretation and the weight that you put on rehabilitation, restitution, healing, it's really important to be transparent in the decisions of the court rather than an informal kind of conversation and without going on record about what the person has done to warrant a 60% reduction on the starting point. It's so important to be transparent about what we're doing in these problem-solving courts and to reassure the public that these decisions are lawful and principled, fair and just, and merciful.
That's yeah, really, really helpful. Thank you so much. I can see somebody's put in the chat that they could sit and listen to both of you all day, and I could as well.
Oh, that's very kind. I couldn't sit here all night, I'm sorry.
No. No, and we shouldn't ask you to do that. We've also got some colleagues from Australia and other people that are on the call as attendees. So there's other people that have given up their
in Australia.
Yeah, that have given up their evenings as well. So we are 1 minute to people have got to go to bed or to other meetings, I'm sure, as well. So I just want to say a huge thank you to Oliver for pulling this together and his work that he will do. We will publish and send out to others. And a huge, huge thank you to Judge Malosi as well for giving up her time and expertise and experience. We are really, really grateful and honoured to have you join us for this. And hopefully many visitors will kind of now be making their way over to join you and see your court in action.
I'll put the teapot on.
Great. Miranda will send round things for attendees after in terms of video from this and the links to resources, and we'll circulate questions. But thank you to everybody for joining us today as well, and we hope to see you at future events of ours too.
Wonderful.
Take
care,
care.
everyone.
Thank you.
Thank you.
Thank you, Miranda.
Thank you.
Thanks, Vicki. See you, Ollie.
Bye.
Bye.